Well, one of the things that you should always look for is that is there a document, whether it be a contract that is between owners, whether or not it is a contract between the business and a third party, some type of vendor or an employee. So it kind of just depends on the context, but certainly if you have an agreement between those potential parties in place, a lot of times they will have alternative dispute resolution methods or methodologies that are built into those agreements. So it'll say that, before you can litigate, that you have to mediate. And the judge may order that even if that's not in the agreement. And both parties can volunteer to engage in mediation, even if it's not in the agreement, and even if the judge says no or doesn't order it. A judge very rarely would say no mediation, but if the judge didn't in fact order it, then both sides still could go ahead and mediate. And then there's arbitration, which can be binding or non-binding. And I should have stated on mediation, that's always, the mediator doesn't get to make a decision. So the mediator tries to get the parties together to come to an agreement. So acts as a facilitator, and if there's an agreement, that agreement is binding, that settlement agreement. But if the mediator doesn't get the parties to agree, then the mediator declares what's called an impasse. And once the impasse is declared, then you have to go through other routes, which may involve litigation. But the documents also may provide for arbitration, which can be either binding or non-binding. If it's binding, then the arbitrator acts like a judge, makes a decision. And unless there is something technically wrong with that particular decision, it's binding. So you can't go back and file suit to the court and go, we didn't like that decision. We want to be in front of the judge. If it's non-binding, then the judge can consider the decision of the arbitrator, but it doesn't stop the plaintiff from bringing the action, or the defendant, for that matter. If the defendant loses an arbitration and says, no, we want to go to court, we're not agreeing to this, to pay this amount of money, and so if you want to, you can file suit. And we went through arbitration. So there's mediation or arbitration. And then what people kind of tend to forget when you're dealing with alternative dispute resolution is good old negotiations. People, it depends on the nature of the person, it depends on the nature of the conflict. But one of the things that it's always helpful to have an attorney that is well versed in negotiations is that the attorney typically can remove his or her emotions out. And if you're involved in a lawsuit, even if it's a business dispute, and you're not being sued personally, but the business is being sued, or the business has been wronged, and so they have to file suit. The owners or the principals of the business, or the ones that are running management, they decide that a lawsuit needs to be filed. Especially with small businesses, these are people's babies, the businesses, and so they want to make sure that everything's done right, but emotions work their way in, and when you get emotional, that tends to hurt your ability to negotiate well. Lawyers will huff and puff, and there are all different types of strategies and attitudes to take, and there are some that are extremely aggressive, and then there are some that catch more flies with honey than vinegar, and do really well with a very laid back and calm approach. But typically the advantage of having an attorney do the negotiations is the fact that the emotional element is usually kind of left at the door, whereas with the parties, they bring in all kinds of emotions. So it also helps to have attorneys that kind of buffer that emotional barrier to coming to a settlement.